Welcome to This Might Be Legal, a podcast about legal issues run by lawyers for whoever likes the legal profession. Today we have episode number 5. We will be discussing about what is behind the curtain of a law firm, what clients do not see. And for that I have invited Celaine Vella, my dear friend. We will have a nice conversation together.
Yeah.
And we have a guest of honor, Indy, who decided to actually place herself here because she wants to be part of that podcast. Probably she wants to become famous.
Yeah, I have a feeling she's going to become a lawyer after this podcast, after we've clarified certain things.
She's assessing.
Yeah. Thank you for the introduction, Dominique. So what we'll do in this podcast, I'll be asking you questions. You're a lawyer. I'm a lawyer as well, but for the benefit of our audience and for the duration of this podcast, I will be playing your average person who's not a lawyer. So I'm the non-lawyer and you're the lawyer. So I will be asking you questions and run through certain things which might be of interest for the public out there. Certain questions which they deal with on a daily basis, maybe certain things that their lawyer is actually not telling them, and give them a bit bigger insight into what us lawyers actually do. So shall we dive in?
Let's start.
Okay, so I'm going to start with a very, very big question for you. Why are lawyers so expensive?
Look, a lot of clients are complaining about this, and it's also why out of 100% of people having legal needs, only 10% of people go and see lawyers, because it's expensive and sometimes it's also a bit slow. Mm-hmm. But it's expensive because lawyers' salaries cost a lot of money, right? So running a law firm costs a lot of money. You need to have a professional insurance. You need to have trainees. You need to have fee earners and non-fee earners, and all of that has a cost. And in reality, most of the lawyers are not making a great living, even though it's expensive, because they have to cover up certain costs. So, because also the work is not standardized, and every client have a different requests, and it's always tailor-made, it's very difficult to actually get on a precise fee at the beginning, right? Mm-hmm. So you work by the hours, and the hours might sometimes be difficult to assess.
Yeah. So that is, in your opinion, would you say that is the reason why certain lawyers, they do not give you a fixed fee to begin with for a matter?
There is that reason, and for certain matters it's very difficult, especially in litigation, right? When you have a dispute coming on, you don't know how long it will take to solve it, right? So if you come up with a fixed quote, and then the matters drags on, then you're going to be working as a loss. So the thing is, you can decrease your fees as much as you want. Mm-hmm. You never decrease your liability.
Yeah.
Right?
And in your opinion as a lawyer, when you have a client in front of you, how do you assess whether you're going to give a fixed quote or whether you're going to be billing by the hour?
Look, what we do is, when we know the scope of work, so for instance, incorporating a company, incorporating an investment fund, and you have done that, you can assess more or less the quantity of work. Then you're more comfortable to actually give a fixed quote. When it's a matter which requires a strategies, requires a negotiation, a dispute, then you have to go. You can give fixed fees, but stage by stage, milestone by milestone, you will be able, for the entire process, it might be difficult.
So in practice, what we're saying is that when it is a matter or a mandate, because that's what lawyers call it, it's a mandate. When it's a mandate where you've done it before, you know exactly what you need to do, everything is laid out, instructions are clear, that would be a fixed quote. And then on the other hand, you bill by the hour when it's a bit ambiguous as to where the work is going to take you.
That is, yeah, correct.
Okay, understood. Okay, on to my next question. How can clients better control, or rather minimize, legal expenses without increasing their risk? It's a bit of a tough one, I guess.
Look, I think select your lawyer well. So if you have experience with a lawyer that you know that there is value for the work, then you might be controlling your legal expense a bit better. Mm-hmm. Often you might have clients that says they just want you to spend 1 hour or 2 hours. We had certain clients coming, especially in the Middle East, where they want you to review a number of documents, a lot of pages, and they give you an unreasonably low fee that they're able to spend on this, and you better just not accept the mandate, because again, right, your liability does not diminish because you've been generous in cutting your fees.
Yeah. Okay. Understood. Okay. What do you think clients don't know or understand about a lawyer's job that ultimately makes the lawyer's fees so costly?
The fact that you need to be precise, and it takes time to be precise. So now you do have technology that helps you a little bit better to go faster, especially artificial intelligence. It's one of them. But when you have to actually go through a long document and you have to proofread it, make sure the cross references are correct, make sure all of these small details, it takes time. It's just not something that often clients come and says, but it's a template, you just reuse the template. Yeah, but no, you have to reread everything, because what if there is something in that template that is not accurate?
Yeah.
And yes, I understand the frustration on one end, but of course then there's also doing the job correctly requires you to make sure that you read carefully everything that you've done, or you proofread everything that your associate has done, and that requires a bit of time. And so there is this joke that says, well, you can go to a lawyer that is cheaper, a junior lawyer that is cheaper. He will actually be charging you a lower hourly rate, but he will spend twice the amount of time than someone that is 2 times more expensive. Yeah. Yeah. So at the end, it might be the same. It's just pick your lawyer, get experience, and see who is actually have a good cost to value benefit for you.
Yeah, and sometimes, like you said, cheaper is sometimes more expensive at the end of the day. It's like you're buying a T-shirt, you buy a cheap T-shirt, which you have to change every other month, or you buy one expensive one, which you'll keep for a longer period of time, right?
That's exactly what it is. Sometimes when clients come with unreasonable fees and you say, well, we want to spend $15,000 to set up a fund, and you have to review hundreds of pages of documents, you cannot reasonably do a correct work with that.
Of course.
So you have your liability that is there. But then at the end, you're going to try to optimize your work. It puts your client at a risk as well. And it might cost them even more money later on to actually solve it. Yeah. So, there's a minimum that is required to.
There's always that element of risk, right? Okay, so now we're literally just going to open behind the curtain, and my next question is: how much and what type of back-end work do lawyers do, which most clients are actually unaware about?
So. Clients, they tend to believe that everything that is produced is being done like this, right? Yeah. Because you've done it already. And I just tackled that before, but the fact that you need to collect the information, assess the information, that you redraft everything from scratch, right? So you tend to use what you've done in the past, but you need to amend it, readjust it, realign the terms, realign the definitions. And that takes time, and clients, they tend to undervalue that work. Yeah. And it's true, it's a bit unfair, because lawyers, they tend to charge on an hourly rate, and whether it's low value work for the end client or it's high value work for the end client, it's the same rate. And it's not very practical, right? So if, for instance, a client comes and he says, we have in a conference call, and he has a fraud of 10 million, and you solve it in 1 hour, and you charge him $500 for that. And for another client, you have to actually do a contract, and you spend 1 hour to reformat a document that has not the same value for the end clients, but the same price. And it's true that probably lawyers will need to, at some point, learn to have different rates for different tasks. And probably technology will help that, right? So technology will help lawyers to give up certain tasks which are low value, and probably charge more on super high value task for clients.
Yes. Because most of the times it's the admin work that the client doesn't actually see. It's the going back and forth in an agreement and having to work in section number 6 and then refer to section number 1. And that actually takes time, because if you want to produce precise work, then obviously you have to be cohesive, and you have to be coherent, and you have to go through the entire document.
So we had that in the past, right, in the firm, where clients were saying, $10,000 for a shareholders agreement was expensive. But then couple of years later, they call you and they say, thank you for your contract because, I got a dispute with my co-shareholders and you really protected me. So they were happy about that, right? So, but it takes time until they really assess or they have to actually use the work to make sure that they were protected or not,
Yeah. Very good so far. I'm very proud of you. On to the next section. The next section will tackle a little bit more in relation to legal advice and commercial reality. One of my main questions is because lawyers say a lot of things, and we'll talk about this a little bit later on as well, but because lawyers use a lot of words, a lot of big words, which sometimes I don't feel like someone who's not a lawyer would necessarily understand. So let's say that I went to a lawyer and there's a clause in my contract which I'm a little bit cautious about. And they're like, oh no, that's fine, that's just standard market practice. If you could, in much simpler terms, explain what standard market practice mean, and if I as a person should actually just trust it because it's standard market practice.
So you better trust your lawyer, otherwise you may not change your lawyer. But it is true that when you, especially in the contractual world, so when you speak to a client and he tell you, I need to have that type of contract, that category of contract, or subcategory of contract, then you discuss the main topics. There is a lot of wording in there that has not been discussed with the client. That is standard practice. So, for instance, you'd never discuss with the client the reps and warranties.
Yeah.
So you represent that your counterparty has the legal capacity to enter into that contract, that he has the financial means to reimburse a loan, that he has and it's standard practice to have this in a contract, which are things that you don't discuss with your client. But the industry, the standard of the industry wants you, if you're good lawyers, to have those type of things because it does protect your client. So you tend to extract the information that you need to do the work, so the factual information from your clients, and then you protect his interest. You don't discuss with him all the small details of how you're going to protect his interest. You just do it, right?
Yes. Yes. Okay. So what is good faith then when something is done in good faith, and why does it have different meanings in different jurisdictions?
So good faith is actually, I think it was the first week of my university, the law faculty, where it is the argument of the bad lawyer, right? So you use good faith when you have no other arguments. But why does it have different meanings in different jurisdictions? Because the laws are not the same.
Yeah.
And usually the law is being construed by court decisions. And court decision may construe from one jurisdiction to another one things differently, right? So it might be more precise, wider, and everything.
Okay, so to recap a little bit, one of the most important things you can do if you're a person who's not a lawyer is to be careful who your lawyer is. Do not necessarily focus mostly on the cheapest lawyer, but rather just focus on their expertise and their experience, and to trust them and to make sure that you're actually able to trust them and to trust whatever they're telling you. Such as if they tell you this is in your best interest, this is standard market practice, or that this is in your best interest, you actually trust them. I have a bit of an ambiguous and a funny question, which is, how can two lawyers look at the same issue and totally disagree?
Usually opposing lawyers tend to disagree. So because you're not a judge, so you don't have to have a final decision on it.
Yeah.
But and you want to protect your lawyer and you negotiate. So it depends on certain things. There are a number of reasons why it would be the case. So it could also be the case because the matter is subject to discussion. There's a lot of authors that actually review legal matters, and then they construe, depending on court decision, in a different way certain matters. Opposing lawyer, as I said, right? So you of course you defend a position, you would defend another position.
Of course.
And then in the negotiation, you're going to try to actually convince or scare the other one by telling that your position is correct legally, right? So it's also a game, right? So all of that is a game. So yes, look, if the legal industry and the legal matters were fixed matters, non-matters, you probably also not need any lawyers, right?
Yeah.
It's because it's a bit alive, because legality changes, law change, application of the law changes, court decision changes.
Yeah.
that you need to have lawyers, and then of course the practice changes as well, and over time things change. So you cannot have people agreeing on everything.
That's true, and most things are actually subject to interpretation as well. So you interpret things one way, I interpret things one way, depending on which side of the grass you're standing. Then you'll defend your position, right? So, okay, so we're gonna move a little bit away from the generalities, and we're gonna delve right into contracts specifically, contracts and transactions.
Yeah.
So, from my basic understanding, I can understand that there are some clauses in a contract which are more important than others in terms of making the contract legally binding, valid and legally binding. So, could you please mention some clauses that, as a minimum, you need to have in your contract?
So it's a very broad question. Actually, there's not only one answer to that, because it all depends on the type of contract you have, right? So if you go to a loan contract, you need to have a lender, you need to have a borrower, you need to have an amount, you need to have a commitment to lend, a commitment to reimburse, possibly an interest rate, possibly a termination or reimbursement date, right? So that is the minimum you would want to see in a contract. But then you have all sorts of other things, which are the freedom of contract, which is unlimited or is actually limited by the principle of legality, public order, and certain mandatory laws that applies, and you cannot just do whatever you want. But it's quite broad, right? So there are minimum clauses. The one that you may want to have, what you want to have in a contract, is enough clarity so that if people finally read that contract and disagree on something, the answer is in the contract. What you don't want to have is generalities which will automatically lead the dispute to go to a court. So it's important, if you select a lawyer, that you select a precise lawyer that makes your commitments clear enough, and the commitment of your counterparty in that contract clear enough, so that if someone breaches something, it's clearly indicated that you should reimburse on that specific date, not as soon as practicable. What does it mean? It means nothing, right? So, and so that's basically what it is. So more than a clause is being precise.
Which leads me to my next question. Why do governing law, so there are two provisions in contracts which you'll always see. Why do governing law and ideally, why do governing law and jurisdiction clauses matter so much in a contract?
So you do have international convention treaties, and you do have also national treaties that will help you select if there's no jurisdiction clause or applicable law, select the law and select the court. But you want to avoid, at the moment there is a dispute, you want to make sure that you know exactly in which forum you have to file, and what is the applicable law applying to your contract, especially in international matters, because if it's a country to country, like a French or a German party with a German party, it is obviously German law. But in an international context, an American signing a contract with a Kuwaiti, the set of laws in those countries might be completely different, right? So you don't know, and so it really helps you to construe your contract, right? So knowing the applicable law. So that's standard practice. Is it a requirement? No, but it's standard practice.
It is standard practice. So basically, also the main element and the main difference between the two is that governing law gives you the rules of the game, and the jurisdiction gives you where the game is going to be played.
Yeah, correct.
Okay, so next question. What are lawyers protecting against when they add extensive disclaimers? All these extensive disclaimers that probably everyone out there has received at one point or another from their lawyer. What is the lawyer exactly protecting against?
Look, I think it's a disease of the profession, because you've been exposed to so many disputes that you tend to protect yourself. The shoemaker tried to have nice shoes, and and so you tend to see issues, right? So
Yeah.
because you're a lawyer, you see issues, so you tend to protect yourself against those issues. Mainly this, and also because you have professional insurances, they require you to have some certain disclaimers and waivers of liabilities, but also because sometimes it's difficult to tell you yes or no. It's not either white or it's not either black. It's the end result might depend on certain aspects and usually a set of facts. And the set of facts are subject to constructions as well, right? So one party believes that he has seen this, the other party has seen that.
Yeah.
So it might not be the same thing. So it's difficult to say, no, it's going to be exactly the end result will be like that, right? So you know by your experience, by the applicable law, by a methodology of work that you have, that you believe it's going to go in that direction, but you have to a bit protect yourself because you cannot necessarily give a guarantee that everything will be as you said. It's a contract of best means, not of result, right?
Yeah.
Acting as a lawyer.
Yeah, but that's the main reason why lawyers, most of the time, they would give you actually a qualified response rather than a definitive one. Okay, so if I was not a lawyer, or if anyone else out there is not a lawyer and they need to review a contract for themselves, and for some reason they don't want to go to a lawyer and whatsoever, what would you advise them to look at?
It's difficult because if you don't want to go and see a lawyer and you don't know, then you need to be careful about what you don't know. So how do you know where to look at if you don't know the matter? And if you don't have someone to advise you? So I would invest into knowledge, right? And if you don't want to pay for a lawyer, at least try to read, try to Google, try to ask the right questions. Common sense. Start with common sense, maybe?
Yeah.
You know?
Yeah, that's a good one. And unfortunately, not a lot of people, they think, the way that I see it is that people see a lawyer's job as being super extra complicated. And I'm not saying that it's easy in any way, but I think common sense will get you to the basic at least.
Yeah,
You could review your own employment contract, for example, because if I receive an employment contract, the majority of the people, they don't go to someone and be like, to a lawyer and be like, could you please review my employment contract? The average person doesn't do that, do they? So yeah, I think common sense is actually a very good take on it. Okay, so now we're going to move a little bit to a slightly different topic, and we're going to be speaking about corporate governance specifically, and within the context as well of compliance. So if you have a company, let's say, who has legal authority to bind a company into a contract?
Well, whoever has signatory power. So you need to check, usually the board would have, you need to check, depending on the country, your charter, your article of association, and maybe your commercial registry. Then you also need to check whether those people who have signatory powers have given a proxy to someone, right? So it's not because you work in a company that you can commit that company. Right?
Yeah. And what happens then if someone signs and they don't have authority?
Look, if they don't have authority and the company realizes that, then the contract is obviously not validly entered into. If they don't have authority and the company is acting or receiving the service or acting as if the contract was validly entered, then you might have these court constructions that actually it has been ratified by the company somehow.
Okay, interesting.
But again, it depends on the jurisdictions where you are and everything.
Yeah, of course.
But generally speaking,
always.
if a company hasn't signed, and just be mindful because a lot of contracts do not necessarily need a written form, right, as well. So signature is not necessarily always needed.
That's true.
Unless party agrees that signature is needed. But if the contract is not signed, then you don't agree or disagree on a written form, right?
Yeah, that's true. That is very true. What are the legal risks that arise from informal side agreements or emails?
Look, because most of the contracts do not require a legal form, a written form, then an email can typically be a contract, right? So you need to be careful what you write, you know. And,
even in your emails.
Even in your emails, you know. There's also that the things does an emoji and a thumb up.
Yeah, thumbs up.
Would
Yeah.
that be a consent or not? On a contract, if says
Yeah.
let's agree on something and you just put a thumbs up, is that a yes or no and whatever? There's a lot of court decision on coming up on those things, right?
There's a huge debate.
So I'll be quite careful because I think you, even if you end up winning and saying that it's not a consent, you'll have to spend quite some money with lawyers and court and time
That
and
is very
stuff,
true.
right? So
That is very
so
true.
just be careful what you're writing.
Okay, so a bit more on the compliance aspect. When does legal compliance conflict with commercial urgency?
Of course, I see that every day, right? So where the sales team complain about the compliance people or the legal people, and it says you're killing business, right? So you need to have a risk reward in everything. You cannot be only legal, and because you don't do business, you cannot only do outside of business without having a little bit of legal insight, right? So there is depending on the type of business you are, you need to have a good average of knowing where your risk is, not overprotecting yourself because otherwise you don't do any businesses anymore, but also letting the salespeople do their job.
Yeah.
And it's becoming increasingly difficult,
Harder,
especially in the finance industry where everything becomes a financial crimes or money laundering and stuff. So where compliance officers in that industry have so much power to actually kill deals, and because they would be liable otherwise, right? So it's a tough one, that one, right? So a good company needs to have really a good balance between the two.
With the introduction of the laws and with the increasing of the fines and everything within the compliance and the money laundering aspect as well, it's just becoming harder and harder as well. Mm-hmm. So, okay, so we're gonna move on to the next section, which I call the agree and disagree section. So what I'll do is basically just state a fact or a statement, and I will need you to let me know whether you agree or disagree. Mm-hmm. And if you wish, you can also tell us why you agree or disagree in your decision. So my first statement is lawyers often start their sentences with, "It depends."
Agree.
Yeah?
It is true that it depends because often the client does not come and express itself with. So it comes with a general statement, and of course you need more granularity. So it depends on which case it is, but it's true that we tend to say it depends.
Yeah, and sometimes you're given half the information, so you don't want to bind yourself to providing an opinion as yet, right? Silence sometimes is a legal risk.
It is correct. Sometimes silence might be construed as consent.
Okay, so next statement. Legal advice is designed more to manage risk rather than to enable business.
I disagree. Okay. So I think it depends on the lawyer. Mm-hmm. Sometimes lawyers are being called like deal breakers, right? Certain lawyers are overprotecting their clients. So they protect every small squares, so they are so protective that the counterparty are no longer willing to do business because they feel scared. And so the legal industry should help people to do business. And that means you need to be able to protect your clients where it's absolutely required and draw his attention. That's why we are legal professional, where your clients can take a risk, Mm-hmm. And then he needs to be, of course, aware. You need to inform him, but a good lawyer would be helping his client to actually achieve its business and not to actually kill its business by overprotecting. Being overprotected means that you don't need to be protected because you do no business.
That sounds fair. Yeah. Sometimes you have to win some to lose some. And okay, so next statement. If a clause is heavily negotiated, it probably matters.
At least for one party. I agree.
At least for one of the parties, yeah. Standard clauses are rarely as standard as people think.
Well, they are here for a matter. You know, there's a reason why they are here. So they might be standard. I don't know if standard is. They might be standard practice clause. Yes. Mm-hmm. Agree.
Agreed? The word reasonable causes more disputes than it prevents.
Yeah, but what is reasonable for me might not be reasonable for you.
Yeah.
You know, it's also the term reasonable is very varies depending on the culture of the people and so on.
That is
Right?
very true. That is very true.
A reasonable German is more reasonable than probably another person.
Yes. Okay, we're going to move on to our next segment, which I'm calling Legally Translated. We briefly touched upon this point earlier on, where we said that sometimes lawyers use bigger words, which people who are not lawyers might not necessarily understand. So first I have a question about this, which is, why do lawyers care so much about wording when the intention is so obvious between the parties? In other words, why does your lawyer care so much about the wording in your contract if, let's say, you and I already agreed that we're going to do business, you're going to provide me with this service, I'm going to pay you X amount of money. So why is it so important that we give so much importance to certain words in a contract?
Yeah. Because there's a number of reasons for that, right? So it depends on the quality of the lawyer as well, but also because often the initial agreement, when you decide to do a business together, you never discuss everything.
Yeah.
You know, you just agree, let's agree to launch a restaurant. Let's agree to do a company and do a yoga club. Let's agree to do something. But you never think about what happens if things goes bad. What happens if we disagree in the future? What happens if you work more and I work less? What happens if, and all of that, what happened that could lead the whole thing. It's easy to actually just write the agreement says we agree on this.
Yeah.
But a good contract also it will be used and will be read when we disagree. And then you want to have an answer about how to deal with the matter when you disagree. And that's why the easy agreement from the beginning sometimes become a bit of a longer document.
Yeah.
Because a lawyer knowing all of that will actually try to prevent or try to make sure that you solve the matter. Remember, a good lawyer will do a good contract which will avoid you or will refrain you to go to court because everything is so clear cut in there that you know that if you go to court, you're going to lose anyway, right? So that's what it is, right?
Yeah, that's a very important point that you actually mentioned there. Okay, so in order to make it a little bit more clear for our audience, I have picked random words which I find are used in some contracts, and I'm just going to give you the quote, and then you just let me know in simpler terms what it means for the people out there who do not necessarily understand, so they can get a better understanding of what their contracts actually say. So the first one is subject to contract.
Yeah, so subject to is something that we like using. It's cool, no?
Yes.
It sounds expensive.
It does.
No, subject to means, of course, to the extent that you re-enter into a contract.
To the extent that you, okay.
So it's a condition to entering a contract. So if we enter into a contract, then this will happen.
So up until the point where you actually enter into the contract, there's no validity to it.
Correct, yeah.
So what does it mean when lawyers say without prejudice, when you receive a legal opinion and the first thing that it says is without prejudice?
So that is something that you cannot actually bring up to court.
Okay.
It becomes a matter between lawyers. Usually it's lawyers to lawyer, right?
Yeah.
So when you have a direct communication lawyer to lawyer to facilitate negotiation, to avoid people going to court. So you can start freely to discuss and negotiate certain terms of a settlement. And if you disagree, then you go to court and you cannot bring those the content of those discussions to court.
Okay. Indemnity or indemnify?
So indemnify as a result of a breach of something. You need to be indemnified because you got a loss or you suffered a damage. So the indemnity is how much are you going to be indemnifying the other party. Remember, you can agree that if you breach a contract, you have to pay for my damages.
Yes.
But then you need to, there's a whole thing about what is the damage, right? So you need to evidence what is the damage. And remember, if you go to court, you have the burden of proof to evidence the amount of damage. So if you can have an indemnity clause that says, if you breach that, the fixed fee indemnity will be $100,000, you already made it a bit easier for your burden of proof.
So it's the commitment for compensation, basically.
That is basically this.
What does it mean at the sole discretion of?
Oh, that is when you want to make sure that you are going to give something to someone, but you cannot give it because it's at my sole discretion. I will ultimately decide if it's yes or no, you know.
Okay. Including without limitation.
So that. I think this one was actually made at a time. There was a point in time where I think in England or in the US as well, where lawyers were paid by the words. So that's why American contract are much longer than French contract, right? So and you have a lot subject to including without limitation, any and or, and it goes on and it is mainly because lawyers were paid for each word, so they were adding a lot of word and convincing their client that it would protect them better. So and now you no longer charge the clients by the word, but it became practice, and so you keep them, including without limitation. Means you have an example, but of a list of things, but it can be something else as well, right?
It's not exhaustive. What does the word severability mean?
Look, when you have a long legal documents, it subject due to certain factors, a portion of that document might become illegal or unenforceable, that it doesn't void the rest of the document, right?
And the final one, what does force majeure mean?
So force majeure means you have force majeure, you also have act of gods. You know, it's when it's an unforeseen event coming to prevent the performance of an obligation. So COVID was one of them, you know, for instance, or you have an earthquake, or you have an act of war, you know, something you promise to deliver something in a country and all of a sudden you have a massive war coming in, no more roads to deliver. So it's against your own will, but you cannot just perform your obligation.
Yeah, okay, perfect. So I hope that gave our audience a little bit of an insight as to certain words that they might have come across or they might come across in the future. So thanks to Dominique, now you understand and know what those words mean. Okay, so now we're going to be moving on to efficiency, process, and expectations. So my first question for you is, why does legal work take longer than expected sometimes?
Because we're human. Because you have 10 fingers, you have a keyboard, and because often you cannot be 5 or 10 people to do one document. So it needs one person, and if the document is long, you need to make sure you go through all the documents, the cross-references, that your documents flows is correct, it's legal, you need to check the facts, you need to check the legality, and all of that takes time to be precise, right? So that is also why it's not an easy profession, right? A lot of people say, "Oh, but you're a lawyer, you can become rich, you're going to become, you have a great life." No, it's a lot of hours in the office. That's why a lot of lawyers actually stop being lawyers after a while, right? It's long hours, you know, especially if the client comes at 5 p.m. and asks something, and then it's Friday and you have to spend your weekend in the office because you have a deadline and you have to produce, and it's your liability. Your family is waiting at home. It's burdensome.
Yes.
Right?
And also what I feel like clients do not understand as well themselves is that they come to you and they change things last minute. And for them, it's a minor change. It's something super simple. But what that means for you as the lawyer is that you have to go through the entire agreement and make sure it's
they don't realize it might impact the context. A change of context might impact the entire clauses. Not only one, but several of them. And you have to actually readjust them so that everything works well together.
Yes.
So that your document is consistent, right?
Yeah. Because it's not a matter of find and replace, and then it automatically replaces, right? You have to make
I do believe the artificial intelligence is going to really help on that, and it's already showing some great improvement for us lawyers.
We'll be touching upon artificial intelligence in the next sections. My next question for you is, why are timelines rarely guaranteed in legal matters? We kind of already briefly touched upon this, but...
Well, we try as much as possible to when you tell to a client that you set an expectation, try to meet them, right? So, but sometimes it is also true that the legal work does not depend on one person only. It might depend on other person. It might depend on court. It might depend on a regulator. It might depend on a counterparty. It might depend on an auditor. They might be on vacation. It might be a holiday. It might be a lot of things. So it is true that sometimes it does impact the delivery timeline. Yes.
Okay. From a more company's perspective, how can companies build better in-house legal awareness?
Well, first you need to be aware that you need legal awareness. And a lot of them are not even aware that they need that. Then you need to find the right person. Remember, you need every person in a company needs to have a unique ability. So you need to have someone that understands those matters and know when he can deal with that matter himself or when he has to delegate that to a more expert person than him. Yeah.
Okay. So I have my concluding section for the first part of this part of the podcast. Then we'll move on into the AI, and we'll have a bit of a deeper dive into those questions. So I have a couple of other follow-up questions, if you don't mind. So my first question for you is, how can businesses use lawyers as strategic partners?
I think Americans, and in certain countries, they see lawyers more as business assistant rather than legal protectionist, whatever it is, right? So look, lawyers create a lot of synergies, come across a lot of different people and different businesses. So
she's interested in the topic.
Yes, that is a topic that all of a sudden she gets some interest in. And so you have lawyers that are able to actually drive through and help achieving certain business and do more than just drafting documents, but advising on commercial terms as well, right? So that's why expert lawyers are sometimes good to have in certain topics. Lawyers that understand not only the legal matters, but the financial matters, accounting, bookkeeping, to understand the money flow and everything will really help you to actually achieve a business that you want to achieve.
And at the same time as well, as your lawyer is there to help you. And like you said, obviously you need to make sure that you don't find yourself a deal breaker, because otherwise you're going to keep on breaking deals. But at the same time, a lawyer is there to help you ultimately as their client. What misunderstandings between lawyers and clients cause the most friction? Or at least in your experience, what have you seen? Like if there's like one specific topic apart from...
it's always the same topic, money.
Yeah, the fees.
The fees, I think the fees.
Is the fees,
yes.
Yeah. I think that's a fair answer.
Yes.
I think that's a very fair
Next
answer.
question.
What should every founder or executive understand about legal risk?
Yeah, it's whenever you set up a startup, you need to be aware that of certain legal requirement, because otherwise you can build a great product and then with the wrong legal framework, you lose your product, you lose your company, you are diluted in your cap table, you lose your IP, and there's a lot of things. So I'm not saying that you need to spend all your initial money getting legal advice, that's what I'm saying, but it's something that you need to be aware, at least aware where the bell needs to ring in your head for certain matters. So when you want to be a founder, that is something that you need to have in your package. I'm not saying that you need to be a legal expert yourself, but you need to have certain legal awareness, or to make sure that you don't commit deadly mistakes after having worked so hard and someone steals your company, right?
Yeah. What do you think clients would do differently if they understood how law is applied in reality?
Look, it's a very complex question. It really, I think they would value probably more the working together with a legal professional.
Yeah.
You know, I think the best companies have always been run with a management composed of different
Yes.
talent, and legal is one of them. No, I do also understand that, you know, a lot of companies, certain companies do huge profits, and certain companies that survive, and you want to save and apply your money where it's necessary, maybe in production and stuff like that. So spending all your money in legal would probably not be something. So I do understand this, but yeah, making sure that your contracts are correctly done, that
Yeah.
you know that you're protected a little bit here and there, that if your client does not pay, that you get your money quite easily without spending so much money, and then getting an initial budget. Yeah, finding a good friend in lawyers would be you know, having one in your pocket.
Yeah.
That is understanding would be a good thing.
I totally agree. I'm with you on that one. It's very important, like we said before, where like cheap is expensive sometimes. You choose a good lawyer. It's understandable that they're costly and everything, but at the end of the day, as in you're
And the audience
protected.
now will think that we actually want to convince people to use lawyers, which is possibly true. But it is. We have seen disasters, and it is
Yes.
true that it costs people so much money to rectify after. So just having, maybe doing a couple of classes and having some bell that ring when
Yeah.
they have to ring.
Yeah.
To ask for help, make you save money. Having a good lawyer might have a cost, but nothing compared to the cost of rectifying
Yes.
a matter that went sour.
Yes,
you know?
and that's probably why our conversation is headed that way, is because we've seen the end result of it.
Yeah.
We've seen clients who haven't read their contracts and now they're in trouble, who committed to doing certain things, or they have certain obligations that they had to perform. They didn't perform them in their contract, and now they're in breach. So we've seen it all. We've been through it all, more you than me with your experience and everything. But yeah, so maybe that's why we're steering the conversation in that way. Okay, so that covers the topics in relation to the legal aspects of it. So as I'm aware, and as the audience should be aware by now, you are in the final stages, I would say, of launching Lane, and everything is taking shape at this point. I've done some of my research about Lane and everything, and I have a couple of questions for you. And this section and this segment I'm calling Lane Explained.
Oh,
So I have some questions for you, and let's get to it. So I've seen a couple of videos from you where you say that you've been a lawyer for the past 25. Is it 25 years? 26?
25, yeah.
Yeah, moving on to 26 since it
25.
25, okay. You've been a lawyer for 25 years, and you've mentioned that you have approximately worked in the same way for the past 25 years. Can you just give me a little bit of insight about what that was like?
Look, 25 years ago, so we had one computer for two lawyers.
Just one between two.
One between two. So you were recording. We were using a lot of assistant PAs to actually type for you. So you were recording a lot of what you had to do, and they would get the tape and they will actually type it for you. Now everybody's typing, so that has changed a little bit. Is it more efficient? I don't know. But now we go back to being able to have artificial intelligence a little bit back at that time, because you actually speak to your artificial intelligence, it somehow types for you.
Yeah.
And that is the same way that a very good PA will take your things and improve it for you and make sure there's no typo, proofread, and it will come. An amazing PA would do that. Not as fast as AI now,
Yeah.
but that was how it looks like. Translation was horrible, you know. And I was actually working in the German part, and every time there would be a document needed in French, I would be the one having to translate it. And it takes time, you know, to translate well. You don't translate word by word. You have to actually understand the meaning and do that. And yes, so that has changed a little bit. What has changed also legal research now? Before you had to actually open books. Now all these books are digitalized, so you have search engine, and yeah. So now we will see, because things will accelerate drastically with the technology that is coming out, especially with Lane. It will be a radical change in the profession.
And we need to move with it, right? Just like you said, you used to share one computer between two people, and then we moved on to everyone having their own fixed computer.
And now everybody has a fixed computer, a laptop,
yes,
and a smartphone.
Exactly. And then now we're evolving into this new era for AI, and we have to move with it. It's very important that you actually move with the times. So from our discussion today, what problem are you aiming to solve with Lane?
Look, what I would like to do is, I would like to improve the life of both the client and the lawyers. And again, right, so you work for the firm, you've seen the firm, we have good clients, it's working quite well. Even then, we had people resigning, not because there's a bad atmosphere, there's a good atmosphere, because of the intensity of the work. And because they prefer to be in-house, to have more fixed hours and everything. And all of that we've discussed that now, right? So the manual work, to be able to think, to summarize in your head, to be able to redraft, to realign things manually with attention, requires a lot of attention and a lot of focus, which makes you tired. So, and sometimes deadlines are so short, and you have to actually remain focused for so long. And it's not made for everybody. So if you can actually have the technology and bring the technology to lawyers, where all of that aspect of the work can be given to a technology, and they just focus on the complex, intellectually interesting legal matters, the strategy, being able just to indicate the direction and let technology do the rest, then they can charge even their hour a bit more expensive, because the rest will be done automatically for the client. At the same time, for the client, things will go much faster, because what takes time is not the end result, is to document it. And if that documentation can be done automatically or very fast with a well-trained technology, then clients will actually gain in time, will get lower fees for certain tasks which are lower value for them, and will still have access to lawyers when they need to. So it's a win-win for both. So Lane is really an in-betweener, which is creating an ecosystem around it to facilitate the life of both, right?
That's.
And you know, all of this burdensome work, not only is it burdensome for a lawyer, but it costs them a lot of money.
Yes.
Because you need to surround yourself with so many people. And so at the beginning of every month, you also need to, okay, well, and now I need to generate so much work to be able to cover all my costs. And to do a work that is barely appreciated by a client and see that as a commodity. And so it's very frustrating for both clients and lawyers, because it's inefficient. And so now this technology, and especially Lane, will make it so much more efficient that maybe lawyers and clients will become friends.
Yes,
you know?
Finally, there's no friction between them.
You know?
And also, like, from the lawyer's side, it's way more efficient, because obviously you don't have to enter everything manually yourself, like we were saying before. And then from the client's end, they're just getting their own contracts within seconds. So what does Lane do that a traditional human lawyer wouldn't do?
Well, so many things. Lane.
Tell me all about them.
Yes. So Lane is patient. Lane is patient. You can instruct again and again. It will redo the work. It never gets tired. It's always available. It doesn't sleep, and basically it needs less human force to be able to achieve the same thing, right? So it's a one-stop shop where you draft, you review, you research, and you combine all of it together. Yeah.
Very good. That's going to be very interesting for us too. Yes, we briefly touched upon it earlier on as well, but like I've noticed that in the majority of your videos, for example, you speak about the admin work that Lane is going to mitigate for lawyers. I would assume that from what you just said now, it's mostly the research, it's the actual drafting and everything, and then for lawyers themselves, they would actually be able to do this higher level review when they actually do to actually overview and have the higher level overview of the contract and of the matter, right?
Correct.
Is there anything else of the admin work that Lane is going to be?
So Lane is not a law firm, right? Lane is a tech company. So it doesn't pretend to be a law firm and he's not there to replace lawyers. But what Lane is doing is acting as a lawyer assistant.
Yes.
Which is extremely qualified. And you instruct Lane once, it remembers your instruction. It doesn't forget it.
Yeah.
And he applies it, right? You don't have to repeat. And that is something which is very valuable.
So again, we've touched upon these 2 points as well. So as a lawyer, how can Lane help me? And as a client, how can Lane help me?
So as a client, Lane will already perform a lot of work that you'll have to actually communicate to a lawyer. So Lane will collect all your information, all your data that you need to actually for the drafting of a document, for the analysis of a case and stuff like that. Lane will guide you in the process and will probably be able to issue already certain result for you. And Lane will do that in no time, and because it becomes a standardized process. Not that clients' matters are standardized; they're all unique. But Lane has standardized the methodology of work, so it becomes a standardized process in solving matters, and so it becomes hyper efficient for a client who gets things more quicker and access to it whenever they want at a subscription price, basically, right? So for lawyers, it does a lot. You know, a lawyer, things that you don't see, for instance, we discussed that before. Doing KYC of a client.
Oh, yes. So it seems like Lane is actually the bond that's going to strengthen the relationship between the lawyer and the client as well.
Yeah, for drafting, reviewing, negotiating, you know, when you negotiate a contract, like who is summarizing negotiation, who is actually doing the next draft, Lane will do all of that resolving as an arbitration center, yes.
Lane is the perfect legal assistant that both client and lawyer actually need then.
Let's hope.
That would be all the questions that I have for you today. Thank you so much for being so patient with me and for going through all of the questions, and for the audience for clearly explaining the legal aspects as well as Lane explained. So thank you so much.
And thank you to you, and thank you to Indy, who's been sleeping during work.
Just so interested.
And we're going to come back soon with a 6th episode of This Might Be Legal in a couple of weeks. We'll see you soon.